Great. Thank you all for bearing with us while we ironed out a few tech bugs, and welcome to this afternoon's last presentation, which is called How to Talk to Cryptographers, presented by Dan Shearer. There will be around 10 minutes left at the end, so if you have any questions, please note them and ask them when the time arises. So quickly to introduce Dan. Dan has a long career in open source. Their current project is LumoSQL, which embeds a new form of data security into the widely used embedded database SQLite. Today, Dan shares with us the lessons learned working with developers on this security project. Please welcome Dan.
Well, thank you, Amy. Thank you, Amy. So there's been one or two little mix-ups. I'm very happy to continue with either, but in fact, this is a very related talk of enforcing privacy rights against big tech and big surveillance. So I suppose if I was there, I'd ask for a show of hands. Amy, can you hear me there? Are you expecting everybody how to talk to cryptographers or the wider enforcing privacy rights? Because that is what I am good to go on.
Sorry about the mix-up. I'm happy to listen to anything. It's all good.
It looks like this is a unicast presentation here. Basically, LumoSQL is a project that I've been working on now for 3 years. Mostly launched at linux.conf.au 2020. It's soft launch before that, but that was the big deal. And it turned out one little technical project in the corner with 2 or 3 people has some very big and very significant ramifications. And so this talk is to document the journey that we're on, how it relates to privacy rights in Australia and around the world, and how a different approach from the bottom up might be what we're looking for to solve some of the most pressing and urgent issues. And so this is not necessarily what we see every time. Why do we care about privacy? What is privacy? There are some basic fundamentals about the nature of privacy that I suddenly found myself going back to about halfway through the LumoSQL project. The notion of privacy is more about a tummy feeling. A 2-year-old can understand this. And I really did have to look up some psychology on toddlers and this sort of thing. The notion of privacy as a visceral feeling that psychologists study is about, no, you don't want to be dashed in on when you're maybe sitting on the bathroom or doing something very intimate like that. And it starts to develop about 2 to 3 years old. And we still have it as an innate feeling that there are some things which are very personal to ourselves. We feel uncomfortable if we're sharing them. We can set boundaries. We decide who we share these things with. That is the notion of privacy as a feeling. And that's a very long way away from legislation and tech and my laptop and my phone and things like that. Whereas anonymity is the idea of hiding my identity so that I can act or indeed not act without anybody knowing who it is who is doing those things or who it is who holds that information. Whilst related, it's not that toddler tummy feeling I'm going to keep coming back to. And naturally, security is related to both of the above, but the point of security is that it allows privacy to exist. You can have privacy without security. It's not so common, but it is possible. But generally speaking, imagine if we had a hotel and we had a very loquacious receptionist. And that receptionist decided to ring up and tell everybody in the newspapers who was staying at the hotel. Well, clearly that's a privacy breach. But to fix it, we go and have a word with the receptionist and say, really, that's not the way to behave. And then we fix the security problem, so there is no more privacy breach. And so these things are very separate. And in trying to figure out how can we do something about what is basically an epic rolling disaster of privacy that affects us all and our children, we had to find the details of how do we define these things. So basically, who has a right to privacy? And indeed, is privacy a right? And the answer is yes and no. Now, there's a lot of stuff on the screen right now. We'll come back to that in a minute. But all sorts of exciting things are up here about a Declaration of Human Rights, and Australia has done things like sign and ratify and say, what a wonderful thing about all of these. In fact, the answer is no, we don't have a right to privacy. Not as a right in Australia enshrined in law. Now, there are discussions about aspects of privacy in various laws. There isn't really anything in the Constitution, and there's quite a few court cases about aspects of privacy. But what if you're not an Australian citizen? What if you're an Australian citizen overseas? And so who you are worldwide and where you are depends on whether you have a right to privacy, which seems a bit strange if this is starting from a place of, I feel like I have things that make me uncomfortable if other people were to know them. Why should that change whether I've taken one step to the left and I'm in the border of another country? Except if you're in an island like Australia, all right. And so we're going to have a look at all the different grades, if you like, of people. But the general notion here is that if you are in Europe, then you have lots of rights. They're written down in law. It's very, very clear. Even if you're a visitor, even if you're there as a student, or even if you're an EU citizen traveling elsewhere. If you're in some countries that copy Europe in some ways, then you have a lesser version of that. South Korea would argue it has a better version of that. That's arguable. And then the other countries go down from there. So yes and no. Do you have a right to privacy? A lot less than you might think. And this is really a significant, a significant issue, because most people seem to feel until it's a little bit too late that yes, they have a right to privacy. Now, in 2017, there's a fundamental case in Australia called the Grubb case, where a journalist named Grubb said to Telstra, I'd like access to all of the metadata about me. So that is the information about my personal information. And it went up to the High Court. There was quite an argument about this, and the answer was no. No, you cannot, because metadata isn't really identifying the individual. It's more about how Telstra provides the services to the individual. That was a disastrous decision, because metadata is at the core of a quality privacy regime. And to take the European example, which is some countries have indeed taken on, the concept is it's an ever-expanding cloud of information. So it's that which would tend to identify a person specifically, and that changes by the day as yet another device comes along with yet another way of innovatively using my personal data and giving it to corporations, like how many steps I take. We're all familiar with that one. Yes, but what about the way I walk? That is unique to me. What about in a very genuine case that I was involved in? There's a global name brand charity that often has a humanitarian mission. There's a disaster in some country. These people will turn up. Of the half dozen or so global organizations, they'll be there. There's been a hurricane, there's been a tidal wave, there's been a war, or whatever it may be. And then after this terrible thing, there's people who need help, and what we need is information. What help do they need? How can we deliver what they need? And so, 21st century, we give our helpers tablets, it has a survey, and we go and ask questions. What do you need? How many people are in your household? How many children? Do you have a house? Does it have a roof? Is the roof tin or plastic? Do you have a goat? These are really, really important things. And so then the food and shelter and other aid comes in, and the humanitarian mission is underway, and that's terrific. But then what happens if 2 years later, as that region is starting to pull itself together, somebody decides that they're in charge, and they'll be a government, thank you very much, and they've got a gun to say so, and they would really like all of those surveys. And that's when the information about your information, you may not even have identified a particular child, but you said they were there, or we can maybe calculate the nature of the people by the kind of food that they said that they would like. That is where we have a very direct implication of metadata getting into the wrong hands with an active life or death security risk. And that's a very real one that non-government organizations are dealing with fairly often these days. Now, yes, we should share. Yes, we should be aware. Yes, we should care. And yes, it's deeply related to things that we can feel. Unfortunately, it just seems so abstract. And this is where we have to look at how things are. And indeed, how things are today, in many ways, is not so great. And so what we're going to do is consider, if I'm in Australia, what is the framework available to me? And the answer is, well, there's laws at federal level, there's laws at state level, there's some bold undertakings by the current federal government that they're going to review various aspects of privacy. At the end of 2022, there was a very helpful sounding law passed about improving your remedies. So if there is a mass data breach, then companies have to pay quite a lot of money. They should be worried about that. So hopefully they won't be encouraging mass data breaches. But that's not the whole story. There is no what is called law of tort, or rather tort of privacy, I should have said, in Australia. And what that means is it's not clear that for you, the individual who has had their privacy infringed in some way that maybe makes you feel icky, there's no way for you to say specifically, that harmed me, that is bad. And without a right of privacy, that by default, in many circumstances, we can expect privacy, we're in a fairly weak position. You go into court, you say, my somethings have been infringed. And then we have to scratch around and look for the particular law and the particular harm that was done, as opposed to in many, some rather, other countries where we say, my rights have been infringed, you have no right to invade my privacy and take it away, and that is by definition not allowable. And so that is, if you like, the background. Now, as to the implementation, the law and the courts are really quite slow. And I have some sympathy with this. I'm not sure that we want the courts and so on to be reacting as the tech landscape changes. We don't expect new laws to be issued hot on the heels of the latest product from the latest cloud company. But really, how can they keep up? And the answer is, as things stand in 2023, no, they can't keep up. Legislative environment isn't working for the individual who has an expectation of their privacy. A whole bunch of very large companies and some governments are invading that privacy. What can they do? And the answer is, if they went to court, which very few are able to do, whatever they went to court for is out of date before it's got to court. The data sale industry, the sale of your personal information and my information, is just galloping away. And indeed, it's a global environment here on the internet, and my personal data from Australia or from wherever I'm living is broadly available in other countries, particularly the United States. In fact, just last week or so, you may have noticed there was quite a icky instance where some very zealous right-wing Catholics have been going around spending millions buying up commercially available data, combing through it, combining the metadata in order to identify specifically which Catholic priests they believe might be gay, and then going and doing something very Catholic about it. And this illustrates that there is a large and growing and very unpleasant market in the sale of our personal data, or perhaps metadata, noting that you can do that in Australia a lot more than you might imagine. And so evidence from court cases, even in the regime which is, as I hope to demonstrate, the shining light on the hill in the European Union, is not very comforting. So in 2021, there was a case in Strasbourg Court of Human Rights against the United Kingdom government, not a European country anymore, as you may have heard. And the idea was GCHQ, which is the English or British equivalent to ASIO, conducts mass surveillance activities. That is to say, it scoops up information on its citizens and everybody else's citizens that can get its hands on, and sifts through it looking for things that they regard as suspicious or bad, or that they're just curious about. And although the government, the British government, was told, no, you can't do that as broadly, they did accept the argument that it is possible to limit how broadly you do that. In other words, they did not say there is a whole class of information that you just can't have access to. And that was both a win for privacy advocacy in the sense that, yes, the UK government was told to back off in its mass surveillance, and a loss in the sense that, no, the court did not uphold the notion that the governments are unable to constrain their privacy searches when they have an infinite data set in front of them. Because they can't. That is a technical fact. And so a lot of things to worry about, calling perhaps for a different approach. Now, this is it's a most amusing to me map created by someone called Mordor Intelligence. Now, I don't actually know much about Mordor Intelligence, but I have in fact checked out these countries and the regions and the various laws that apply. It's not too bad. So this is about what is the rate of growth of metadata industry, if you like, data sale in various regions. And guess what? In Australia and throughout Northeast Asia, this is a high growth area. Now, I do note that the Attorney General, Federal Attorney General of Australia, has announced that there shall be a review into the data retention regulations, which is welcome. That is to say, the mandatory requirement on Australian companies that they will keep our metadata for a period of time. But that is not an answer to why is it that Australia and many other countries are in a very high growth area for selling our private data. Now, this is about rates of growth, which is why the United States, for example, is not growing as fast as others. It's extremely mature there. Still, I do think that was valid. I was interested to see that others have done the work, and I've checked it myself. Yes, if you're in Australia, they're coming for us. Now, this brings me to a very important, fundamental, if you like, epiphany for me. In 2015, the beginnings of the European GDPR was starting to coalesce. What are we going to do, they were saying, in Europe? And we're going to come back to this slide you see a couple of times. I'm going to flick away from it because I'm not going to read it. This is my personal epiphany moment in developing the LumoSQL open source solution and understanding what it might mean. Because in the beginning, in the recitals of this document, the introduction, if you like, it doesn't just talk about the right to privacy, which is there. It's in the UN Universal Declaration of Rights. and its various instruments as ratified and signed by Australia, but not implemented in Australian law. All of these things are there. But what was astonishing to me was that the human rights framework as a network, as an interlocking collection of rights, is specifically referred to in the European General Data Protection Regulation and other regulations like it around the world. Now, it was quite a revelation. If we go through them, you skip towards the end, this regulation is going to respect private and family life, home communications, okay. But freedom of thought and conscience and religion, that is fundamentally connected to privacy. Your freedom of expression and freedom to exchange information, which may not be in any way personal, that is a right, again, enshrined in the UN treaties. And founding a business, if something goes wrong, the right to appeal and say, no, this isn't right, to say a court or other thing, that's called an effective remedy. If you're accused of something, a fair trial. Privacy is clearly involved in that as you talk to various people, including your lawyer, about what's going on. And then, of course, a whole host of issues around sociological things, languages and religions and cultural beliefs. All of these things are in the beginning of the GDPR as saying, look, you can't really have them if you don't have privacy. And that was the aha moment for me, because privacy rights effectively are human rights. And even more so in the current age, where if you think of, for example, the right we have in the UN Charter of Rights to clean drinking water, which is obviously much more important, much more of an issue in some countries than others currently. But how do we get to that? And somewhere along the line, there'll be an email, there'll be WhatsApp, there'll be maybe Signal or other communications related to that right being delivered and guaranteed. And that relates to the privacy of the individuals concerned. So what I have concluded, and what many others conclude as well, is that digital privacy is the way that all other rights are respected and delivered in the 21st century. And that is why it matters. And that is why the current situation really isn't good enough. The GDPR has some flaws. It also has 6 or 7 siblings in EU law that put privacy rights and associated mathematics, as we're going to talk about, at the heart of everything that happens online. Other countries have taken this on. New Zealand, indeed, has a privacy rights regime which is compatible with the GDPR. So does Japan, so does South Korea, Brazil, and Canada has some degree of commonality as well. And we can tell that this is so because the European Union has a thing called adequacy, which, whilst far from perfect, says we believe that this country and the way it handles personal data is roughly compatible with how we do it here in Europe. So it's a bit of a gold star for privacy excellence. Unfortunately, there's some holes in that, but we're beginning to see that the European approach is a race to the top. And I feel quite strongly there's a distinction between what we're doing in Australia, what we see in New Zealand. And I think, well, there's actions that need to be taken, and there's votes that need to be had. Even the current government, and it's very different to the recent government, federal government in its approach, but even the current federal government has acknowledged that there are all manner of things that aren't good enough. And so this is a quote from the Attorney General, Mark Dreyfus, about the mandatory data retention regime not being good enough. I would add quite a list to this. There's been a privacy isn't up to scratch report hanging around for about 4 years at the federal government level, with a lot of recommendations about how to tighten things up. None of them address the biggest issue in the room, of course, which is that Australia believes in bulk surveillance. It's in lockstep with the United States as the main partner in this, in something called the Five Eyes Agreement. So that's Australia, US, New Zealand, Canada, and United Kingdom. All of them Anglo countries which have decided that they will exert their every ability to hoover up as much data as possible and sift through it basically without oversight and share the results. None of that is touched by what Mr. Dreyfus is saying, although I'm very glad he's saying that our metadata is more important. And so, this is where we get to the pointy bit. One moment. The pointy bit is what can we do? And the we there is from me and my trusty team of open source developers, me as an Australian and you as Australian citizens, and everything in between. And so one of the very simple things is we have to think about our technology choices. These are positive actions that many people can take in their daily lives to some extent. It's not all gloom and doom. And so people that have a privacy geek in their lives will have heard them banging on about, is the source code available? We make a purchasing decision. Is the source code available, at least for the most important components? The answer is very rarely 100% yes, because at some level, devices are locked down. There's source code relating to your firmware in your phone, and so on. It's a really good first pass test. Now, at this conference, I don't have to say too much about that. But, for example, I know groups of young people. I was delighted to discover that they didn't need a lecture from the likes of me. They'd just gone out and bought something called the Free Phone, and there's 4 or 5 others around there, which doesn't have Google all through it at every level. It doesn't have closed source applications where there is an obvious open source alternative. It isn't reporting by default your position and many other personal facts about you back to a central cloud, be that Samsung's or Google's or whoever, Huawei's. That is delightful and a really good example of an individual action. You'll find this conference is absolutely full of people who will bend your ear about a very long list of options. But even thinking about it is a good step forward. And there are horror stories around now that non-technical people are beginning to realize, actually, this is a serious problem. Now, when it comes to cloud suppliers, this brings up end-to-end encryption, particularly, for example, for chat services or video services. And the answer to that is, if it isn't effective end-to-end encryption, and by effective, I mean if somebody hasn't responded to government requests to make that stream available to any government that asks, if it has effective end-to-end encryption, then that's what you want to go for. And there are some tests for that. I am not a fan of Facebook, Meta, or WhatsApp, ultimately. But I will say this, that WhatsApp does have end-to-end encryption. Now, a lot of the metadata is not secure, and we can tell that with WhatsApp because they are looking at introducing carefully targeted ads. However, I'm going to say something nice about WhatsApp. They said they would leave the United Kingdom last week if the United Kingdom passes a law which says all end-to-end encryption shall be compromised with the UK government having a key. That would effectively outlaw WhatsApp in its current incarnation, and they said they would leave the country. Now, good for them. I would suggest maybe not using WhatsApp at all. So Signal, again, while not perfect, those who know me are aware I'm part of a project to implement Signal server not as part of signal.org. But Signal is the best we have today. And Signal is not only got end-to-end encryption, but it is very careful about the information it leaks about who you're talking to and who else might be in a group and where are they from. And so when it comes to Australia's data retention law, for example, the most that somebody like Signal.org can supply them is an IP address and some metadata that can be pulled out of the likes of Cloudflare. So basically, Signal.org is largely impervious to the Australian government's mandatory data retention laws. That's a great example of something to choose. And then finally, monoculturalism is not a social statement of something terribly controversial. It's simply the fact of if I have 10,000 pieces of technology in my company or in my local council, and they all come from one supplier, they all have related source code trees, then they are probably all vulnerable to the same privacy holes. And that is why a lot of places, including some enlightened local councils, are deciding that, okay, they are going to have electric vehicles which have all manner of problems with their software stack, including privacy, but maybe we'll get one from this Asian country, one from the United States, and one from Europe, and mix and match our fleet. It's not so great for some fleet managers, but it's not a bad protection against privacy and quality issues in the software stack. That's a very crude example, but that level of thinking is being increasingly applied in larger organizations around the world. In my house, I'm an individual, and that level of thinking still applies. So there are some things that I will give to one large name brand cloud provider because I'm in the real world, I have real people I deal with, they are dealing with these clouds. But then there are other classes of my personal information that I give to other clouds. If I'm careful, very careful, then with the knowledge that I have, with the research I've done, I'm able to reduce my privacy risk overall. You've probably heard me being very careful there, pulling back a little. It is not clear-cut because, of course, there are issues of combining data. The large clouds do like to combine data and triangulate into us. What can they deduce? It's not easy, but there are some actions we can do. There are some recommendations we can make. Many lists of them around. I'm going to give a few a little later on. And the most important thing, which is actually not on this slide, is that individuals can vote. Now, we saw at the last federal election what can happen when people get fed up and decide to voice an independent view. And that has made a significant difference at scale. Similar things have happened in Chile, going back a few years in Brazil, certainly in countries in the EU, where individual citizens have decided enough is enough, and they have lobbied for successfully actions at the ballot box relating to protecting privacy. We have a rich series of targets in Australia here. We have some great advice related to privacy. We have this privacy review. We have the proposed review of metadata changes. We have some terrible pieces of legislation that need to be called out. There is the 2018 Access Act, Access and Assistance Act, which basically says the federal government has infinite access to anything happening in Australia, and if there's a technical person involved, they can be required to give the federal government a back door, and they can be required not to talk about that, and they can be threatened with jail if they don't. This is a malign piece of legislation, and the only way to deal with that is in the Australian Federal Parliament, and the only influence we have on that as an individual is at the ballot box, or through lobbying, or through joining with others. So there are things we can do. It's not gloom and doom. It's not the end of the world. It's pretty worrying. And of course, one group of open source developers have decided to do something else. We thought, this is a bit rubbish. What can we do? What if we started from the bottom up? Is it possible that we can do something regardless of the legal regime? So we have some star actors behind us, from SSH way back when to Signal, more modern. There's the Guardian project, which is, and of course Tor. Wonderful pieces of open source that have decided that they can assist with privacy and security regardless of the legal regime. Great. But as we've just seen, for the individual user, in practice, non-technical person, they're really stuck in a hard place today. So everyone has a mobile phone, and we've studied this quite carefully. There is quite possibly one way in. It's rather ambitious, but we've made considerable progress. So every one of your mobile phones has a database on it called SQLite. It's the world's most used software. It has an extraordinarily good history for reliability. I used to think otherwise, and then I realized that firstly I was misunderstanding, and secondly I was misunderstanding the scale. There is nothing else, as far as I know, that is non-trivial software at trillion scale, and it is at trillion scale. If you take out your phone, there is at least 300 databases, SQLite databases on there. If it's not streaming data, it's probably in SQLite. Most of them as plain text SQLite. It is possible to encrypt an entire SQLite database if you do the right magic. And so what if we could make a small change to SQLite? It would need to be a small change. You don't fiddle with trillion scale software lightly. And what if we could in some way give user permissions enforced in SQLite? And that's what we've been working on for the last 3 years. And the answer is we can. And in fact, we have solved the how do we modify SQLite without breaking SQLite problem. We believe we have done. We've worked very carefully with the SQLite community to ensure that we do. We believe we've solved the problem of what can we give the individual user in meaningful control. So there was, unfortunately, the industry hijacked the infamous cookie laws in the EU deliberately and made it so that we all suffer from click fatigue, saying, yes, I accept cookies, da-da-da. How can we meaningfully give users control over each row of data in SQLite? And the answer is with something very clever. We use mathematics. We use a form of encryption that is called attribute-based encryption. The idea is that you can read or write the data depending on the keys you hold. And the user can delegate keys. Imagine, for example, we think of a class of application on our phone, banking apps. What if the bank was not in charge of the permissions over that data? If the user could say, the banks can only read the data or append to it, but they can't rewrite anything. That is an example of what we're heading for. So by default, the telephone operating system that you're using, whether it's Apple or one of the Androids from Huawei or no matter who, if it's a particular class of application, the user can select what that application is allowed to do, and the permissions are in the data. So wherever the data goes is where the permissions go. Now, the technical details of that are really quite immense. There's quite a lot to understand. How does attribute-based encryption work? Why have I got both a PhD and a master's and some very competent developers in addition working on this in Rust? and integrating that into SQLite. All of this is really quite technical, but the basic issue is it's possible not only to enforce these permissions, but to roll them out at scale if we get some ducks lined up, such as approaching the platform owners. I don't know who we have in the audience from Google and Amazon today, but I want to hear from you. There's new namespaces. There's all sorts of exciting reasons why you might want to get in making privacy enforceable from the user up. Now, adoption from app developers, that's a bit of an easier door to push because the current encryption options for SQLite aren't great. And we believe that we have a way to fix that. We're very pleased with our measurements so far. We want to talk to you. And finally, it is ambitious to the point of hubristic. But what if every telephone had this? What if every line of every data, of every SQLite database had these permissions associated with it wherever that data went? That would be an industry default, and that would be privacy from the bottom up. So that's what we're aiming for. I understand that's the 10-minute warning, which means we have some Q&As.
Thank you, Dan. Unfortunately, that's the end. We've come right up to our...
I have a room coordinator here.
Sorry, say that again.
Hello, Amy.
Hello. Unfortunately, that's not the 10-minute warning. We've come up right against our finish time at 5:25. So
have we just now?
We have just. Sorry. So sorry, we're not able to take...
So thank you very much for that.
Thank you. Thank you so much. And apologies again for mangling your introduction. Thank you for picking up a very strange ball and running with it. Thank you so much. And thanks to everyone else here. We'll see you tomorrow, hopefully, or at dinner at 6 p.m. Thank you.